Welcome to the Crime Redefined podcast, produced by Zero Cliff Media. Coming to you from the US Bank Tower, high above downtown Los Angeles. In our podcast, we drill deep into forensics and criminal investigation from the viewpoint of the defense, as well as explore the intersection of the media and the justice system.
Hey, Crime Redefined listeners. Thanks for joining us again. Or if you're a first-timer, welcome. I'm Dion Mitchell here with my co-host, Mehul Anjaria. In this episode, we're going to do a really deep dive into the world of digital forensics. Our special guest today is a friend of my co-host.
That's right. Mark McLaughlin will be our tour guide as we do this deep dive into digital forensics. Mark is a friend of mine, and he's also a colleague. We're both on the Los Angeles Superior Court Expert Witness Panel. So as a result, Mark and I are sometimes working on the same case. Mark McLaughlin is an expert in both digital forensics and police practices. And Dion, if that's not enough, he's also got a law degree.
Mark is really a bit of a Renaissance man, Mehul.
Yeah, he is indeed.
He graduated from the Long Beach Police Reserve Academy and then served as a volunteer firefighter. And then after working as a digital forensic examiner for over 20 years, he founded Computer Forensics International in 2001.
And Computer Forensics International specializes in the use of cutting-edge analytical and forensic analysis techniques for collecting, accessing, and reconstructing electronically stored information. That's also known as ESI, Dion, and Mark will break that down further for us. So this information that he's accessing and reconstructing, it's coming from computers, servers, mobile devices, such as a cell phone or a tablet. He's getting it from cellular networks. Social media is a biggie, of course. Storage media. And then in the law enforcement realm, from the body-worn cameras that the officers should be activating, and also the in-car video systems in police cars, such as a dash cam. This ESI comes from video surveillance systems, local and internet email repositories, and other media sources. And, you know, the other is a catch-all to capture the future. I mean, who knows what kind of technology we'll have? And, you know, now there's Alexas and all sorts of interesting sources of this ESI. So all told, Mark McLaughlin has handled over 500 cases and examined well over 2,000 items of evidence involving state and federal crimes, civil matters, and even government internal affairs investigations.
So many missing persons and court cases can benefit from a thorough digital forensic exam. One of those cases that is at the top of mind for us, of course, is the Terrence Woods case. And we'll ask Mark about that and to find out what should have been done in the initial part of the investigation, as well as what can be done now in assisting finding Terrence.
Okay, before we start, just a little bit of a word of warning. This material can get pretty detailed and sometimes down in the weeds. And, you know, Mark gave us just a ton of information and was so generous with his time. So I think what we're going to do is we will break this into a two-parter, Dion, and I think it'll just make it a little bit more digestible for our listeners.
Absolutely. And just for you listeners out there, just hang in there. This is going to be worth the wait. Mark is really knowledgeable in this space. So for all you true crime fans, podcasters, and researchers, think of this interview as cliff notes to all things digital forensics.
All right, Dion, let's go to digital forensics school.
All right, let's do this. Hey, Mark, thanks for joining us today. We're super, super excited to speak with you.
Yeah, it's a pleasure to be with you guys.
Okay, so you ready to dig in?
Absolutely.
Okay, so tell me how you got here. What initially drew you into the field of digital forensics?
Yeah, it's somewhat of a circuitous route. I had a friend that was an LAPD commander for South Bureau Homicide, and he retired and went to a PI firm, private investigation firm in LA called Investigative Group International. And he had his computer involved in a case, and he said, you know, I don't know much about this. This is back in 1996. Maybe you can help me out. He knew I had a computer background, a law enforcement background, investigative background. And then I was able to help him out. We were successful, and it's never stopped since.
So you say you had a computer background. What is, like, you know, he knew you had a computer background. What does that represent?
Right. Well, I was a IT manager. I actually started back in the late 80s just doing basic operations, with mainframe systems, doing backups. Then moved on to desktop support as PCs started to become more prevalent. Desktop support, became a manager. I was a network manager, project manager. Ultimately, I became a project manager for infrastructure projects worldwide, and then with a subspecialty of turnarounds. So if you had a project that was failing, you'd call me in, and I'd put the project back on track.
Wow. So that's actually really cool. So you've like literally been at the forefront of this wave. So you've seen it all, because that's, when you say 90s, even though for some of us, it's not super long time ago, but that's the Stone Age as far as digital goes. And so you've really been right in front of the wave all the way up to today.
Right. It's interesting you mentioned the wave, because that's exactly what I say is I've been riding this wave ever since 96, and it's only been getting bigger, and it just hasn't stopped.
Well, Mark, let's start with some definitions here just to kind of get our listeners warmed up. So
Sure.
Can you explain to us what ESI is and why that is really the best term to describe the type of evidence that you look at in your work?
Right. Electronically stored information is the term du jour that you use in the legal business about electronically stored information that's used in cases. So instead of using data is kind of a broad term. The courts came up with this electronically stored information, or ESI. And ESI is the way that we describe the evidence that we retrieve and then analyze that evidence. So it's a very specific way to take a look at the items and have let's put it this way, frame it in a certain way that you're going to be using it in a legal process. And so when we talk about ESI, if you mention that to anybody, they're automatically going to know that you're a level up from someone just talking about data.
Yeah. And did you say that the courts actually coined that term?
Yeah, it's something that the federal courts have been way ahead of this rather than the states. And because they realized that they had this problem, that the problem was electronically stored information is being involved in cases more and more and more. And it's turning cases. So because it's so important, they had to frame it in a way that they would come up with things. And the courts are really good at coming up with acronyms for different things. Certainly
Yes, they are.
Yeah, that's really interesting. And I'm going to kind of roll that into something you partially answered, and it's a softball based on that answer, is what's the difference between an IT professional and someone who is specifically involved in digital forensics?
Yeah, it's interesting. People and lawyers too think about electronic evidence, IT work as really the same thing as in digital forensics, and it's not. While they used to say that anything has a cord or has batteries is something we examine, that's kind of true. But it really comes down to using it in a legal setting. And digital forensic examiners are trained to retrieve it in a way where we protect it and preserve it, and then we analyze it in a way that is non-invasive. And then from that, we take it to the reporting phase. And so we're pretty well versed at handling it that way. We know how to testify and write reports. IT professionals don't. That's not what they do. Although they may deal with the same type of ESI in devices and certain types of devices, mobile or computers, it really comes down to what's the ultimate use of this. And if you want to use it in a legal setting, you better get somebody that knows how to work in a legal setting rather than the guy down the street or Best Buy that knows how to retrieve information, but they can testify to save their life. So,
well, yeah. And so to that end, Mark, how many times are you on one side of a case and the other side puts somebody up on the stand or uses them as a consultant who really is just an IT professional and they're not trained in forensics?
Yeah, it doesn't happen that often anymore. It did happen years ago because there was this commingling of, well, you're an IT guy and people refer to me as an IT guy. I'm a digital forensic examiner. That's different.
I was going to say, that's a little bit of an insult, right?
Yeah.
Well, nah, I didn't take it like that. But I mean, I just want to make it clear. And, the legal business is that. It's establishing these boundaries and these very clear lines. And that's what, that's pretty much what the difference is between the two.
I have a question that you just mentioned about being that's non-evasive. So when you're brought in to work a case, let's say it's a laptop, for example, and you're doing your digital forensic scrub, so to speak, in a legal setting, is that when you do that, and you said you do it in a way that's non-invasive, correct?
Right.
Is that ever turned and used against you? Like, does whoever you're opposing say that based on, let's say, what you come back with is not good for their argument or their side? And do they ever say, well, because you went in there, you corrupted X, Y, or Z? Is that ever flipped on its head and used against you? Like there's no way to go in there and retrieve this without corrupting or without any invasive work?
Right. So one of the basic tenets of digital forensic examination, all of it, is that you do not modify the original item of evidence, period, unless there's absolutely no other option. But there's usually a lot of options. So what we use is specific tools that we use what's called a data write blocking device. And what that does is it creates a one-way data highway from the device to our acquisition laptop. And from the acquisition laptop, we can retrieve all the information there, except we don't change anything on the original item of evidence. Thereby, that original item of evidence is preserved and it's not changed. So you can go back to the original item of evidence and then
compare the two.
Pardon me?
Like compare the two.
Right, and you would look for changes to metadata, and metadata would be the easiest things to change on something like that. And you would see if you touched a file, you could have a different access date, possibly a different modified date if for some reason you opened the file and changed it. So that would be a problem from the chain of custody, because what we do in digital forensics is we are one of the few disciplines that can actually create a copy of an item of evidence and then it be admitted as an original.
Wow.
That's right.
Is that absolute? What you just described, that scenario, is that something that's absolute?
Pretty much. Yeah.
Okay.
I mean, there are times, I guess, there are exceptions to everything. I mean, you go to law school, there's an exception for everything, and as you find. But I know that that's pretty much the way it's supposed to be. And if for some reason you modified the evidence, you better be able to explain it.
Right.
And if you can't, then you have a break in the chain of custody. Remember, we work in a digital world. Everything is digital now. When I started back in '96, it wasn't so much. We had, computers, cell phones occasionally. I mean, they were the big brick honking things that you saw. Certainly, there was no social media. Email was just kind of coming on the scene. Now, everything is pretty much digital. Even, of course, photographs and things are digital. So if you make modifications to it, it's not the original item of evidence. It's not the original item that you're looking at. And so can it be relied upon? That's what the courts are trying to establish is no, you can't do that. You have to have an unbroken chain of custody on an item of evidence to show that it's the actual item. And that's pretty much what we do.
And you're saying that there's basically a metadata trail if that were to happen? Oh,
yes. Yeah. You could find, if there's a question about the preservation of the evidence, you can go right back to it and you can see it. I had a case which was a insurance fraud case. And they were, it was state insurance fraud investigators. And instead of using a data write blocking device for this Mac, they just acquired it. And I looked at it, I said, what we're looking at, we look at the acquisition date of when did they first physically acquire the device. So if they did a search warrant or they did some type of retrieval of this item, and then so we know the date that they've got it. And so that from that date forward, there should be no changes to that evidence at all. Well, that didn't occur on the item of evidence. And they had a lot of explaining to do. And of course, what happens when you call them out on that, they're doing a lot of tap dancing and trying to figure out, now, how are we going to handle it? And then is it possible that the weight of that evidence would be less? Yes, it is.
So, Mark, I want to move from modifying evidence to out and out deleting it. So can you give us a little bit of an education about, what happens when we're just using, say, word processing? We delete a file on a computer. And I think we've all heard that it's never, ever completely, truly deleted. But why is that? And then how do you go about finding things that may have been deleted? What are the tells? What are the digital signatures that something's been deleted?
Right. So when you're acquiring electronic evidence, we typically will acquire it in a physical nature, meaning that we will acquire everything that's on a hard drive, everything that's on a USB drive. And when we acquire this, we acquire everything, including what's reported to be deleted, active and reported to be deleted files. So then once we acquire that, we're able to take a look at it and see if it's active or deleted. When something is deleted, well, let me step back. I think we need a little foundation here.
Yes.
When you intend to write something to a piece of media, a USB, a hard drive, media like that, what you would do is you first format the drive. And when you format that item, it says, okay, I'm taking the operating system and I'm putting these sectors and tracks on this item. And what it does is it organizes the piece of media so that you can store information to it and retrieve it in an organized way. So when we write files to it, the files are written inside these tracks and sectors. All storage devices, all of them have that, all of them. So it doesn't make a difference if it's a square, if it's round. I mean, it's all the same thing. So then you store these files to the piece of media. And the files may not be stored contiguously. We got the motorcycles going by here. The files may not be stored contiguously, so they may be across multiple tracks and multiple sectors. The thing that keeps track of that is the operating system. And it says, oh, okay, I know where this file is because I know this element, and this element. I'm going to pull it together. I'm going to show it to you. And that's when you recall a file from a piece of media. When something is deleted, you're telling the operating system, wait a minute, I don't want to see this anymore. And it says, oh, okay, you don't want to see this anymore. You're going to delete it. So what we're going to do is you're going to take it to the recycle bin. That's one option. Recycle bin says, and it's just like a trash can, and you just throw things in the trash can. You're not going to see them as active, but it's actually still there and easily retrievable. Once you say, I'm going to empty this trash can because I don't want to see it anymore, then it is absolutely deleted in a way that it may be recoverable. And let me explain. When the operating system says, when you tell the operating system, I don't want to recover this anymore, or I don't want to see this anymore, all it does is delete the first character of the file name. That's it.
Interesting.
When it deletes the first character, it says, oh, well, you don't want to see it anymore. I'm not going to show it to you. However, it's still there in the spaces that it was previously written to. And if you want to retrieve, and if you want to use these spaces again, because it'll be much more efficient on your system to reuse space, of course, then I'm going to allow these spaces to be reused. Doesn't mean it's automatically going to be reused, but it can be. And that's referred to as being overwritten. So you can overwrite a portion of a file. You can overwrite an entire file. And if you do that, it is unretrievable. So the whole idea in our business is to get to a file that's in a deleted state, but not in an overwritten state. And when something is not overwritten, then you can recover it. Certain files need to be recovered 100% intact to be valuable to your investigation. And that would typically be videos, images, and audio files. If we do a partial recovery of those, you may see a little bit of the picture, but you're not going to see anything else. And I'm talking about just an image file. An audio file will not play, and a video file will not play. So that's an issue with those types of files. However, with a text file, where it has this ASCII characters inside, just text characters, then that may be helpful because you could maybe see phrases, paragraphs, previous versions that are sitting out there somewhere on the drive that you can recover, or possibly the entire file that you could recover. So the recovering files, it's a big part of what we do. The systems typically do it in an automated fashion. However, there's ways that we can go in and carve, and it's using certain algorithms in our forensic software that it looks for, let's say, a header of a JPEG file, which is an image file, a JPG file. And it's looking for that type of file. And it says, okay, I've got the header. This is what the JPG file looks like from a header standpoint. This is what the footer looks like. And then it takes that information and scours the piece of media for it, the hard drive, the USB, whatever it is. And it sees if it finds any of those characteristics. If it does, it exports it and says, okay, I've got a possible hit here. Take a look at it and see if it makes sense to you. Sometimes it works, sometimes it doesn't. Because it's important that you get those files intact. But still, with some of the text information, you can still be very helpful on a case by just doing a partial recovery.
So let me be a little devious here, Mark. Let's say I want to cover my tracks. I've got this smoking gun file on my computer. I first put it in the recycle bin, then I empty the recycle bin. If I do a defrag or a disk optimization, is that going to make your work harder recovering that file?
Quite possibly, yes, because for a couple of reasons. One is the file could be overwritten in part or totally. And if it's overwritten, that's very difficult to recover, if not completely unrecoverable. However, there may be instances where in the recycle bin, there's a file that keeps track of all the files that are in the recycle bin. That may be recoverable. And if you see that this file was there at one point, and it was maybe on the drive too that you could see, and then you're looking on the drive and you don't see it, then you know that it's been deleted. And if you have this recycle bin database that you've identified the actual date and time that it was there and deleted, then you have an intentional deletion of evidence or spoliation incident.
Well, I was asking for a friend, and his name may or may not be Dion.
Huh.
Thanks.
Sergeant Schultz, I know nothing, I hear nothing.
Oh, it was just the stuff that you gave me, Mehul.
Oh, okay. Ouch.
Okay, so you kind of mentioned this, and I'm ready to tee this up as a DNA boxing match between you and Mehul. You mentioned once that digital evidence has become the new DNA in criminal cases. Would you elaborate on that, and then let the lines drawn, and let's go to battle?
Yeah, Mehul, it's nothing against but DNA certainly came on the scene, and it made a big hit with being able to turn a case. But it's very specific in its usage, meaning that not all cases have DNA. You have to give some type of biological item, I guess, DNA, or Mehul, you can talk more about the biology of it. And I need you to give me that CLE, by the way, Mehul.
Absolutely, I will return the favor.
Okay. But it seems like it's much more specific to biological substances in DNA. DNA for electronic evidence is different, and it touches just about everything in our lives: our phones, our cars, our houses. I mean, I've got a completely wired house here with Amazon Alexas all over the place. So, it's just everywhere in what we do. We have the email; it's just all over the place. Does it turn a case? Absolutely. And I've done it over and over and over again in my cases. And so I coined the phrase, it's the new DNA, and it just seems to react that way.
Well, kind of getting into some of your cases, Mark, I know that you offer a training seminar called Win Your Case with Digital Evidence, even when it's not directly involved. And I was wondering, could you go through perhaps a couple of examples where there was digital evidence, but it wasn't directly involved, but yet it became, powerful evidence in the case?
Yeah, it just happens a lot. I would say, let's see. We've been getting a lot of these restraining order violations, and these are typically civil restraining orders that become criminal when you violate them. And so what we found is that there's a way that you can spoof the the entry, let's say, of somebody that's, well, let me give you the hypothetical. The hypothetical is there's an individual who has a restraining order against them, and the person who issued the restraining order, requested the restraining order, doesn't like this person, kind of in a husband and wife situation or boyfriend girlfriend situation. Typically it occurs. And so they want to get back at this person who's the restrained person. And so what they can do is they get these, there's a way to spoof a contact, meaning that I'm going to say, I'm going to, well, let me give a little bit more detail. If I'm restrained, when I'm a restrained person, I'm restrained from making contact with this individual, whether it's in person, electronically, or even down the street in certain distances. So how do you show that this person was not involved in that? And so I recall a couple of cases where they got emails or they got texts, and typically it's a text or maybe it's a type of call that they would make. Generally, a text is less. They can't track a text and show that somebody's trying to, at least they think somebody's trying to feign the thing and make it not real. So what they'll do is they'll have some texts that they'll send to themselves using this spoof type of capability. And a spoof capability is over the internet, you can buy this access that allows you to purport yourself to be whoever you want to be. I could be Mehul, I could be Dion, and I could use your phone number and put it in there, and I can send a text and people think it comes from you. And it registers on your phone just like that. So I've had those types of cases where it's not directly related, but it's something that we're able to go in and take a look at. In an instance like what we just talked about, I would look at the call detail records of the sender. And if the sender has no activity associated with sending that text or contact, then I can say that it was a spoof because it was not something that they did. You have to analyze their phone, you look at their call detail records, and I've testified on that very effectively. It works. So that's where it does. It's not a direct effect, but it's a tertiary effect. Also, there's ways to show that people were not in a certain area at a certain time. Let's say that you're in our same hypo here, you're accused of violating the restraining order because you're within 100 feet of that location. Well, there's an area called Google location. Google location is essentially a GPS in your pocket. And everyone that has a Google account has Google location. It may or may not be turned on. It's typically on by default, but you can turn it off. Also, even if you turn it off, if you use certain Google apps, it'll turn it back on again. So with that, we can go into their account and take a look at the date and time that they were alleged to have violated this restraining order and see exactly where they were. Sometimes, we can show that they're not even close, not even the same zip code, what they're saying. So with that information, that can be very powerful to refute something that wasn't directly involved. It's just like he said he was right outside. Well, he wasn't outside. He was around. He was, a mile, 2 miles away at another house, whatever it is. It wasn't at the location. That's the main thing. So that works very effectively.
You mentioned call detail records, and I've got a question about that. I was at the jail yesterday talking to a pro per, and he was saying that in his case, there's a claim that there was a FaceTime call. Now, of course, the pro per would like to get the record of that. He told me that the district attorney told him that a FaceTime call will not show up on call detail records. Is that accurate?
Yes, that's correct. Because
really?
It goes over the Wi-Fi system or the internet, and it circumvents the call detail records wireless system. Although there would be a data entry hit on the call detail records.
Oh, interesting. Okay.
Yeah, so that would show up because you have to have data usage. Now, that should show up on there. That's right. But the FaceTime is a proprietary communication way that Apple put together so that Apple devices can talk to each other. I know that I think that there may be some apps. Well, I know there are apps that you can use for Apple to go to Android and communicate. But this is typically a Apple issue that they've got, and they pretty much lock it down. I mean, it's just something that they came up with. They were the first ones to come up with it, and it's very effective. But it does circumvent that system.
Hey, this is great because all of this is kind of leads me into my next kind of question. And that is, I learned about just recently was the geofencing or reverse location searches.
Yeah.
Can you explain, what that is and how it's used in criminal investigations? And the second part to the question is, what's the impact on the Fourth Amendment?
Yeah, geofencing is a huge area that's only going to get bigger. And let me explain what geofencing is. So geofencing is essentially putting a coordinate, a box, an electronic box around a certain physical area on the Earth. So you take coordinates of, let's say, a block. You could make it a block size.
Can I interrupt you just for a quick second? Is there any restrictions on the size of that? Because you just mentioned a block, but how big can that original umbrella be?
Well, there are no restrictions, but you shouldn't make it too big, because if you make the area too big, then you could catch more things that you're actually looking. Just
more data that you got to wade through, right?
Exactly, more ESIs you got to wade through.
Okay.
And typically, well, it's not as much the ESI, Dion, as the more results, the search hits that you're going to get from Google. And this is how the geofence works. So if you have a known location of an incident with a known date and time, then what you do, and this is law enforcement activity in a search warrant, what they'll do is they'll create a search warrant with those locations that they believe this individual that they're trying to find was moving through. So, for instance, in LA, we've had a lot of these smash and grab robberies, smash and grab burglaries. And there's not a lot of people around at the time when these go down. Typically, individuals will carry their phone with them wherever they go. I mean, you don't go into another room in your house with having your phone with you. So to say that an individual would leave their phone in their car or leave it at their house when they go out and do these crimes, that's generally not true. They generally take the phone with them. However, sometimes we'll see that they'll flip it to airplane mode, and that's quite possible. That's certainly an allegation that law enforcement makes a lot. So when they don't have a hit on something. So back to the geofencing, when you have this incident location, let's say at La Brea and Melrose, where we've had a lot of break-ins at the Melrose location, we know the time that it occurred. And we know the location it occurred. So that's one geofence location. Now, you could send that to Google, and Google would give you an anonymous return based on the amount of hits that Google would identify in their system for this mobile device number. Every time when you create a Google account, your phone number is associated with that Google account, and it tracks it. So it's able to show those two together. And so what happens is you send that warrant off to them, and then you'll get a return. The return will say there's a bunch of numbers. I think it's like a 12-digit number, but it's an anonymous number. And it says, okay, we've got 5 hits. And these 5 hits are for that location. You'll say, great. You'll send another request back to them and say, give me those 5 hits and all the subscriber information. Once they give that to you, you can use departmental resources, departmental databases to determine who this person is and see if you can identify this person. If you have, back on the initial request, if you have a very broad, Dion, this kind of goes to your question, a very broad area that you're going to include, and it's not as specific. Maybe it's 6 blocks, 10 blocks, something like that. You're going to catch a lot of anonymous hits, and you may get 300 hits. Well, you don't want to go through 300 hits.
Right.
That's really not very effective for you. So then you would want to cull that data down as best you could to a smaller data set. One way to do that is to come up with entrance and exit points from the incident location. So if you believe this individual came up La Brea through Rodeo and then made a left on this street, and so you can come up with additional locations. If you know that they were there, if you believe that vehicle was there possibly, that you can identify, then you can cull the data down a lot more. So instead of 300 hits, you may get 2 hits or 1 hit. And then you go back to Google and say, hey, give me the subscriber information. They'll give it to you. And that's how they identify individuals. And it works very, very well.
Wow.
And by the way, Google is saying now that over 50% of the search warrant requests and legal process requests they're getting are these geofence warrants.
So law enforcement's really leaning on this stuff now.
Oh, yes. Oh, yeah. Oh, yeah.
So talk to me about the impact on the Fourth Amendment. Like, where does this go sideways?
I know it's been an issue. I know that it actually started, Dion, back in the East Coast, and it started to come west. And one of friends of mine said, hey, we're seeing this back here in, I think it's Virginia, and they're developing this, and it all of a sudden it starts to show up on the West Coast as, oh, yeah, it is coming here. And it is an issue. One of the issues was that the warrant is an anonymous warrant. And an anonymous warrant is referred to also as a general warrant as opposed to a specific warrant. Generalized warrants are generally not admissible and an issue. And that's why they're trying to be more specific. It's not really been litigated completely to the Supreme Court, but courts have allowed this as someone that doesn't have a right to privacy, just like, and that's really where it stems from, a Fourth Amendment violation. You must have a right to privacy of that information. For instance, your bank account. You don't have a right to privacy in your bank account. And so that's where a lot of the arguments come from, is that it's very similar to that. Yes, you have an account, but it's not private. It's owned by somebody else, and they can do with it what they want.
Okay, so now my question is, is a workaround until there's a Supreme Court case that sets precedence for this? Is there a workaround that law enforcement can use using a general to narrow the search and then flip that once they have basically culled that information into a more specific one? You know what I mean? So I'm trying to, can you baby step it till you can be more specific about a specific search warrant? Can they move from a general and then move that into something specific to get around that a little bit?
Right. Well, they don't characterize it as a general warrant. They characterize it as a specific warrant.
Oh, they do. Okay.
Yeah. So that they don't think that there's an issue there. So they're
going to do it until someone stops them.
Well, yeah. I think that's pretty much the way it is, and that's the way that the government's going to continue to operate until somebody does it. And that's the reason that we have the Constitution, to restrain and constrain activity that could possibly violate certain provisions, certainly of someone's privacy to certain information. So, yes, it's something that law enforcement continues to push the boundaries. And technology is the thing that's pushing it. I mean, we're the ones that are doing it. They never had this information before. It's something that has been developed over the years, or an idea. It's like, well, we got this capability. What about this? What about doing it over here? And that's the way that things get adapted, and it works very effectively. Not only, by the way, is these geofence warrants, are they effective with Google? Apple will be the same way. Because Apple collects this information, the same type of information that Google collects, and they can regurgitate it just the same back to in a search warrant return of someone who serves a warrant on them.
And they have to comply, correct?
Yeah, there's a hierarchy of compliance when it comes to these social media companies. And the hierarchy starts with a search warrant. That's the top level. When there's a search warrant, that tells them that a judge reviewed everything in the warrant, and the warrant is relevant. It makes sense to this case. It's something that they need, and they're going to give it to them. That's what the social media companies read into when it comes to a warrant.
Got it.
Next is a court order. A court order is something similar, but a court order can be also a criminal and also in a civil area. And with a court order, it's a very similar thing in that the judge has reviewed the request by the party and says, yes, it makes sense, and I'm going to issue this order. And so then the social media company says, okay, if it's a court order, we'll buy that. Then the last thing is, and we'll respond to it. The last thing would be a subpoena. Now, if you're a licensed attorney, in most jurisdictions, you can write your own subpoena and serve it on anybody. It does not have to be reviewed by the court. Except in a federal jurisdiction, if you're an out-of-district subpoena, then it has to be reviewed by a court. But in general, it does not have to be reviewed by a court. So that's why the social media companies give those extra scrutiny to the point that they may just even ignore it and say, we're not going to give it to you. Or they'll use what's called the Stored Communications Act as their authority for not giving it to you. The Stored Communications Act is a federal act, and what it refers to is the private information of individuals of ESI that they store on their systems. And that's what it's designed to do, is protect that privacy. However, we found in a lot of instances where we're trying to request our own clients' information, they even say, well, we're not going to give it to you because it's an SCA violation, and we're not going to do it. Say, okay, good. Here's we're going to hear this case. We're going to make a hearing on this, and we're going to haul you into court. Oh, okay. Wait a minute. That changes things. So if you're prepared to go all that way, you'll get what you want eventually. But if you look at the hierarchy, and I know we're talking about crime, so you would typically see the search warrant be the vehicle that gets them what they want.
Just a quick comment here. There's a bit of a parallel in the DNA world when we're talking about sort of a generalized warrant. Sometimes there's a situation where there is a DNA profile of the assailant that's developed, but it's not matched to anybody. So you can't say who it is. You just know that there's this, almost unique genetic code. And the problem is that there's a statute of limitations on many of these cases. So the solution in the DNA world has been to do what's known as a John Doe warrant. And it's basically not on a particular person, but on that genetic profile. And that's kind of the way that they have used to kind of preserve the statute of limitations.
Interesting.
Yeah.
Yeah, it is there. Yeah.
So I wanted to talk about a case that's hot in the media right now. And that's this Alec Baldwin shooting on the set of the movie Rust.
Yes.
And so we just heard, I think yesterday, that now that there's a search warrant for Alec Baldwin's phone. And presumably they want anything that's on there, but there may have been some discussions between him and the armorer before the movie was actually shot. And I just wanted to pick your brain a little bit, Mark, given the fact that it's been 2 months since the incident, how will investigators recover any deleted information from the phone? And just big picture in general, how will they go about analyzing this phone?
Yeah. He's been very vocal about what's gone on here. If I was a lawyer representing him, I would say, zip it.
Right.
He just keeps talking and talking and talking. Yeah. And I could see later on somebody taking excerpts of this and using it against him. So, not a good idea to be or let your lawyer be the one who's talking rather than you're giving these interviews. But in any event, with regard to electronic evidence here, I think that there's a lot that could be relevant. In the phones themselves, you can have text messages going back and forth to individuals. You could have calls going back and forth. You could have emails and voicemails back and forth, which could be recoverable and relevant. You might also have location information, which the phone can record exactly where you are. And it uses many different sources, Wi-Fi, Bluetooth, GPS to come up with locations. And so if for instance, they can identify that there was a location that they were doing this plinking. I know that was part of the case, part of the investigation. They identified that individuals had an area that they were actually shooting, plinking, shooting guns. And, he's referred to as plinking cans, shooting cans kind of thing, off fences or something like that. And to me, that would not be unusual in that type of area. However, if you're doing it on a movie set, shouldn't be doing that stuff. That's not a good idea. No, you don't do that. And that's what leads to what happened in this case. So with the electronic evidence, you can show that somebody was at a location when they say they weren't there. You can show that they had communications with someone when they say, oh, I didn't know anything about that. Well, yeah, you got a text message right here that said, and you replied, that's a good idea. Or you gave a thumbs up, something like that. That's all retrievable. If you have information that you've got that shows it was deleted and is it very relevant to the case and detrimental to that individual, that would not look good. And that could be a spoliation issue, certainly on a civil case, a spoliation issue. And it could be obstruction of justice on a criminal case if you're deleting that information. So there, not only in the electronic evidence do we have that, but also call detail records. Call detail records could say that, yeah, and by the way, I would bet they've already got that. Okay, I know they have a search warrant for his phone, but I'm sure they issued search warrants already in the background for all the individuals' call detail records. And then there also may be what else? Not call detail records, but backups. We have, if you have an iPhone, you back up your phone to iCloud, right? So they could issue search warrants for those, and he doesn't even know it. And so they could be analyzing those backups, and then they're getting ready to interview him. And so they want to get the phone. They already know the answer. I mean, a good lawyer knows the answer before he asks the question.
Yeah.
The investigator does the same thing. And so you want to know the answer before you ask the question. And so that's why you do those investigative steps. So there's a lot going on in the background.
Thank you for listening to the Crime Redefined podcast. Like us on Facebook and follow us on Twitter at Crime Redefined. Please send us your comments and questions and join us for the next episode.